In the previous lesson, we talked about sexual offences and one of the major elements relating to sexual offences, which is, of course, the obtaining of consent for sexual activity. Now, we also finished that lesson by talking about Section 76 of the Sexual Offences Act, which outlines one of the ways in which a rebuttal of consent can be presumed on the basis of deception. Now, there are a few different modes in which deception is essentially conceptualized within Section 76, and we're going to talk about them in this lesson, and we'll talk about some of the cases which illustrates the point relating to deception and the different kinds of deception which can negate the idea of consent. So, talking about the view of deception in view of sexual offences and looking at some of the case authorities on the matter, that's essentially what we're going to do in this video. Now, the concept of deception as a method for enticing sexual activity is one that is present in some of the early authorities on sexual offences and consent. A lot of these cases actually predate the Sexual Offences Act, and so the issues relating to things like deception are baked into the Sexual Offences Act, owing to the fact that these are issues that had to be dealt with by the courts previously, before 2003. So one of the earliest cases, for example, is the case of Crown versus Flattery from 1877. Now, it's relatively easy to understand why an individual has not consented to activity in these cases because of the sheer level of deception that is essentially on display in these examples. So, for example, in this case, the defendant had utilized deception when they tried to persuade the victim that he was performing a type of surgical operation that the victim had required. In reality, he was actually just having sexual intercourse with her, and she was deceived into thinking that this was some kind of surgical operation. As you can imagine, it was held that even though it was clear that the victim had consented to the activity, they had consented to the activity on the basis of false information. So they had consented on the basis of fraudulent information. And so as a result of this, even though the victim in a lot of these deception cases consents to the activity, they're not consenting to sexual intercourse, they're consenting to being to the deceived activity. The victim here wasn't consenting to sexual intercourse, she was consenting to a type of surgical operation, if you will. And so as a result of which, they were not consenting to the activity of sex. So, one of the more famous cases, which takes place post-2003, post the passage of the Sexual Offences Act, is the case of Crown versus Jeter. Now, in this case, the defendant had deceived the victim into thinking she would be in trouble with the police if she did not agree to have sexual intercourse with him. Again, this is on the basis of Section 76, and the question here was, does this count as deception on the basis of Section 76? Because one of the problems with this case is, with previous examples, with the example that we just saw, the case of Crown versus Flattery, you have the example here of an individual who is having sex believing that what she is doing is actually not is not sexual intercourse. So she believed it was to do with a surgical operation, and so a result of which is that they were deceived on the basis of what they were doing. In future cases that we're going to look at in a second, there's examples where there are doctors or medical professionals who give fraudulent breast examinations on the basis that for them is that so they can essentially have a feel, and then for the victim they think that they're having a legitimate examination. And so in those cases there is deception as to the act, but in the case of Crown versus Jeter, you haven't got deception as to the act, because what we have here is that the victim knows that she is having sexual intercourse with the defendant, but she's doing so under the false pretenses that she would be in trouble with the police if she did not agree. It was held by the Court of Appeal that the ambit of Section 76 is limited to, quote, the act which it is said to apply. And so as a result of this, the concept of deception in relation to Section 76 refers to the nature of the act. And so there wasn't deception here as to the nature of the act. There would not be deception as the nature of the act in this case, because the deception isn't of the nature of the act. The victim knows that they are having sexual intercourse with the defendant. The deception is in relation to the consequences of not performing the act. Okay? And so deception for the purposes of Section 76 is deception as to the act itself. So if a victim consents to sexual activity believing that what they're doing is not sexual activity, then that is Section 76 deception. But when it comes to believing that what they're doing is sexual intercourse, they know that they're having sex with this individual, but they are doing so under the false pretenses of the potential consequences resulting from the act. In the case of 2000, we have the case of R versus Tabasum. And in this case, the concept of deception related to specifically deception as to the purpose of the act, and so would have fallen under Section 76. In these cases, it's easier to show violations of Sections 2 to 4 of the Sexual Offences Act, because this was, if you remember a couple of minutes ago, I mentioned this was deception as to the purpose of a breast examination. The defendant had deceived the victim into believing that the breast examination was done for medical reasons, and in reality it wasn't. It was done for the purposes of basically touching another individual for sexual gratification. And so the result of this was that the victim was deceived into thinking that what they were doing was undergoing a medical examination. They didn't think that what they were doing was being involved in some kind of sexual activity. And so this would have, if the legislation was here, fallen under the remit of Section 76. Comparing that to R and Jita, where it wasn't the act that was being deceived, it was the consequences of the act, which was where the deception lies. The final part of Section 76 makes mention of the idea of impersonations. What if you impersonate somebody else and therefore have sexual intercourse with them because that individual has consented to having intercourse with the impersonation but not with you? This has always been a very uncontroversial element of the law of rape and any other sexual offence, really, but it often takes place in the context of rape. So I'm just going to go through it in relatively quick fashion, if you will. It states that if the victim is unaware as to the identity of the individual to whom they're having sexual intercourse with, and they're deceived into the identity, they believe that they're having sex with somebody else. You might be thinking, well, how is that even possible? But if for example, it's the middle of the night, for example, and an individual breaks in to somebody's home and starts having sex with one of them, and it's so dark that you can't see, and maybe potentially you're just working on, you're delirious, and you then consent to that sexual activity, you can see quite easily how they might have falsely believed that they are having consensual sex with someone who they should be wanting to have sex with, not an individual who's broken in. That's just a crazy wild example, but often it is the case that it's sometimes difficult to ascertain factual circumstances in which impersonations are even possible, and it's those kinds of situations where this kind of thing arises. If the defendant is impersonating somebody else and the victim does not know who they're having sex with, then how can they reasonably have consented to the intercourse? There's one of the interesting elements of consent in relation to sexual offences is that it is more than just consent to sexual activity, but it is also consenting to specifically sexual activity with a specific person, not just generally consenting to sexual activity. Because if they would not have otherwise consented, if they had known the true identity of the individual who they're having sex with, then this would constitute rape for the purposes of Section 1.